You know, a brand name can be like a company's soul. It's the one thing everyone recognizes. But what happens when the company itself just fails? Who gets to own that soul when it's suddenly up for grabs? Well, that's the heart of a really fascinating legal fight over a single name.
So here's the big question. When a company goes under, who gets its most valuable asset? Its name. This case is all about the name Gloster. And it's a real tug-of-war. We've got a healthy, running company on one side, and on the other, the administrators of its bankrupt former partner. And they both say the trademark belongs to them.
All right, let's set the stage for this legal showdown and meet the two main players at the center of this whole thing.
Okay, so in one corner we have Gloster Limited, let's call them GL. They're up and running, and they insist the Gloster brand is theirs completely. In the other corner, we have the administrators for Gloster Cables Limited, or GCL. Now, GCL is bankrupt, and their team argues that the trademark is an asset they can sell off to pay the company's debts. Now, to really get what's going on here, we need to rewind the clock. Because this isn't just a simple disagreement, oh no. It's a story that's been woven through decades of really complex corporate deals.
It's actually fascinating to see how this whole relationship evolved. It all kicks off back in 1998 with a pretty simple agreement letting GL use the name. But then, in 2007, things get much more serious. GL formally licenses the trademark. And by 2012, it all leads to this thing called a deed of assignment, a legal document that was supposed to transfer ownership for good. This was supposed to be it, the end of the story.
And that right there is the absolute core of GL's argument. For them, that 2012 agreement wasn't just some random transaction. It was the finish line of a journey that had been going on for 14 years. The brand was finally, officially theirs. Or, well, so they thought.
Because you know how these things go. Just when it seemed like everything was settled and done, a massive financial event happened that threw the entire ownership of the Gloster name right back into question.
And that twist has a specific date, October 12, 2017. This is the day that Gloster Cables Limited, the original trademark owner, was officially pulled into insolvency proceedings. The company was going down.
So this event kicks off what's called the Corporate Insolvency Resolution Process, or CIRP for short. You can just think of it like a referee stepping into the ring. A team of experts comes in, takes control of all the company's assets, and tries to figure out the best way to pay back everyone the company owes money to.
So it all boils down to this. On that crucial date, October 12, 2017, who legally owned the Gloster trademark? Was it still an asset that belonged to the bankrupt GCL, which the administrators could then sell? Or had it already been permanently moved over to GL 5 years earlier? I mean, this is the multi-million-dollar question the courts had to figure out.
And this is where it all escalates into a full-blown legal battle. So let's break down how each side made their case.
GCL's administrators, they came out swinging. They claimed that the 2012 transfer was basically a sham. They called it a preferential deal, which is legal speak for a deal designed to help out one party right before a company goes bust. They also said there was a pre-existing court order freezing GCL's assets, making the whole transfer illegal. But GO's defense was all about that long history we just talked about. They argued this wasn't some last-minute shady deal. It was the logical end of a long relationship where they were the ones actually building the brand's value. This was the legal linchpin for the administrators. Their argument was that because a court had already told GCL they couldn't sell assets, that 2012 deed of assignment was basically dead on arrival. It was, in their view, legally worthless from the second it was signed. But Gloster Limited's response was just as firm, and honestly, a lot more fundamental. They weren't just arguing about whether a document was valid or not. They were arguing that the brand itself, the very idea of Gloster, was never really an asset of the bankrupt company in the first place, because its value and its identity were built by them. So, after hearing all these arguments, digging through decades of agreements, and trying to figure out the real intent behind all these transactions, the National Company Law Appellate Tribunal was finally ready to make its call.
So who did the courts say owned the company's soul? Was it the firm that first put the name on paper, or the one that actually gave that name its value in the real world?
The court came down decisively on the side of Gloster Limited. Here's the breakdown. It said that the 2012 deed of assignment was, in fact, valid. It ruled the transfer was not some shady deal to cheat creditors, but the fair conclusion of a long business relationship. And here's the kicker. It determined that the trademark was not an asset of Gloster Cables Limited when it went into insolvency.
And really, this one sentence from the final judgment says everything you need to know.
The court looked past who simply registered the name and looked at the entire history, concluding that the brand's true home was with the company that had actually nurtured it, not the one that was being liquidated.
So the key takeaway here is a pretty powerful legal precedent. The court recognized that a brand's identity, its history, its goodwill, can be legally separate from the corporate shell that just happens to hold the registration. In other words, the name Gloster belonged to the company that gave it life, not the one that was dying.
And this whole ruling leaves us with a really provocative thought. It suggests a brand is so much more than just property you can buy and sell, like a building or a bunch of trucks. It's a living thing, an identity that you build over time. And that raises a fascinating question for any business out there. Where does the true value of your company really lie?